Good evening, colleagues, or good afternoon. I don't know when you're watching this. I was privileged to be asked by your professor to give a few minutes of a practical trial attorney's experience as it relates to trials. The art of the trial. Well, first of all, as you know, the trial is broken down into many parts, and I'm sure you've studied them all. Really, the first opportunity, aside from voir dire, is when you give your opening statement. I know you're probably very terrified about giving an opening statement. I was too when I started, and I am now, even though I've been practicing law for 3 decades. The best way to settle those butterflies is complete and adequate trial preparation. What I mean by that is know your facts, start at the bottom line and build up. If you're prosecuting a criminal case or defending a criminal case, or if you are a plaintiff's attorney or a defense attorney, know what law applies. Know your facts. You can hold your own with the very best trial attorneys, even if it's your very first trial. All you have to do is work at it. One way I prepare for my trials is I immerse myself in the facts. I try to put myself where my client was. I try to put myself where my client is. I try to see the case from my opponent's point of view. If I can prosecute my client, I am certainly able to better defend my client. I try to think like my opponent. This way, I am better able to anticipate his or her theories of the case, his or her witnesses presentations. Let's start with the opening statement. You know, years ago when I was a young guy starting out, a lot of times we just blew it off. Don't ever do that. The opening statement is the most marvelous opportunity you have to speak to the fact finder, be it the jury or the judge, unfettered by interruption. Most good trial attorneys have enough common sense not to interrupt their opponent's opening. What do you say during your opening statement? Well, that all depends on your trial preparation. You know your facts, you know your law. You've thought about your case. Your case needs a theory. Your case needs an aroma, hopefully not a stinking aroma. Your case needs a concept. So you build your entire anticipated presentation throughout the entire trial around your case. You have this in the back of your mind, of course. You have this in notes. I presume you've done all of this. When you give your opening statement, firstly and very basically, obviously, you stand, address the court, Your Honor, and then look over to your opponent, counsel, and then address the jury. Speak English to the jury. Don't use $3 words. Give a chronological presentation of the facts that you determine to be relevant that fit in your theory of the case. Don't jump around. Don't go from one day to the next and back to the first day. Avoid cliches. A lot of times, and when I was a young guy starting out, and I still see it now with the less seasoned attorneys, they'll stand up to talk just to be talking. Don't do that. You want to present your opening statement as if you were hearing your opening statement as a juror. Think like a juror. What does that juror want to hear? Well, He wants to hear what's alleged, what the law is, and why your client is not guilty, or if you're the prosecutor, why the defendant is guilty. Avoid saying words such as, "Now, ladies and gentlemen, it's my duty to tell you what occurred during the events of February 26, 2012. Ladies and gentlemen, what I'm about to say is not evidence. What you will hear during this opening statement is not evidence. It is merely what the evidence will show." Avoid this. Try to make yourself connected to the jury. Say things such as, "You know, folks, we're going to learn at trial that medical testimony will be presented that will show such and such." Or, "Ladies and gentlemen, what happened on that day we'll all hear from various witnesses." So try to unite yourself with the jury and avoid the cliches. One way is to show the jury that you believe in your case. You don't have to fake it. You don't have to phony it up. Put yourself also in the position of your client. Believe in your client. If you believe in your client, you'll believe in your case, and it'll come across to the jury. Once you've made your opening statement, thank them for their attention, and then be seated. Direct examination is something that you have an awful lot of control of. Direct examination, as you know, is of your own witness. Now, you view your potential witnesses as an opportunity to present a chronological version of what you want the jury to hear. Now, you can also do this through cross-examination, and we'll get to that in a minute. But direct examination is where you use each witness as a piece of your presentation. For instance, occurrence witnesses, those that have observed the event that is at trial. Take them again in a chronological order. Some occurrence witnesses can only testify as to certain aspect of the occurrence. One good way to start it out is to, of course, you introduce them to the judge and the jury. And what I do in the beginning usually is, would you please state your name for Judge Levitt and the jury, so we get to know you better. And she'll state her name. Do you remember being present at the intersection of Hunt Club and Route 132 on February 26, 2012? Yes, I do, she says. Well, what about that date and that location calls those facts to your mind? In other words, you want to show the jury that the woman has a present sense recollection of the facts. If you've properly prepared your witness, or if your witness is of the type of a mental capacity, cognitive capacity, where they can articulately express themselves, you can just let them go. What did you see? What did you next see? What did you do? What did you hear? And then you can go, and then what happened? And then what happened? And then what did he do? Things of that nature are very, very easy. Frequently, however, you'll have a witness that just gets paralyzed on the witness stand. And you'll have to, even though it's direct examination, lead them around like a baby elephant. Now, you can do it without getting objections if you say words to the effect, "Mrs. Smith, I'd like to direct your attention to Hunt Club in 132. You were there on that date at about 2:22 p.m., were you not?" "Yes, I was." And you were there in an automobile? Yes, I was. As you were approaching the intersection, did you see a vehicle ahead of you? Yes, I did. Now, at this point, a relatively inexperienced attorney may interpose an objection to say that you're leading, and then your reply would be, Your Honor, it's precatory or it's foundational to her relevant testimony. May I proceed? And then you'll get the admonition by the court. And then you'll go on and do it anyway. So just bring the witness to the fact. If you want the witness to testify, to get out the fact that upon approaching the accident scene, you approached the driver and that she didn't smell any alcohol, but she smelled a sense of cologne, so to speak. And as you approached the driver, was he still seated in the car? Yes, he was. What did you smell? Well, I smelled cologne. Well, you know that because you've already prepared her for that. So what you want to do is take it in very simple chronological order what each witness will say. And you're going to build your trial technique based upon what of your other and or succeeding witnesses will say. Now, when you get to cross-examination, we have all been taught by our very intelligent and smart professors, never ask a question that you don't know the answer to. Well, that's good advice. And don't ever do it. How you phrase your questions on cross-examination, you've all have heard this, they should be closed-end questions, where the elicited answer from the witness is implied from the question. Frequently, you'll have a witness that just doesn't want to give you the time of day. Officer Smith, can you tell me what time did you arrive at the intersection of Hunt Club and Route 132? Well, I don't know the exact time, counsel. Yes, officer. I didn't ask you the exact time. Could you tell me approximately what time you arrived? Well, I'd have to look at my notes. Now, at this point, don't let the witness use this type of a technique to take your cross-examination away from you. You know what time he arrived there, so you could say, Officer, you would agree with me, would you not, that you arrived there at 2:32 p.m. In the afternoon of February 26, 2012. Is that not correct? Well, I don't know. Officer, the question that I asked you is, did you arrive there? Yes, I did. Did you arrive there at 2:26? Yes or no? I don't know. Officer, you would agree with me if your reports say that you arrived at 2:26, that you did arrive at 2:26? Well, yes, if my reports say so. You see, what you want to do is maintain control of the witness. Now, during cross-examination, it's very, very important not to fight with your witness. If your witness isn't answering your questions, be patient and ask the question a second time. If the witness doesn't answer the question or gives you a narrative response, just say, that's all very interesting, but what I asked you was, and then repeat the question. On rare occasion, ask the judge to assist you in directing the witness to answer the question. You can tell a story and get your theory of your case out as easily under cross-examination in most cases as you do in direct examination. The key to successful cross-examination is knowing what your witness will say. Basically, you have read the reports, you have read the discovery, or if it's a civil case, you've read the answers to the interrogatories, you've read the transcriptions of the depositions. You know what the answer will be. So very calmly, methodically, and respectfully, be persistent and ask that question. Once the cross-examination aspect has been over, of course, the opponent will have a chance to redirect. Now, be cautious and don't let these people jump all over you, because they'll try to frequently go into redirect examination what they neglected to do in the direct examination. So always be aware of the very, very helpful objection. Your Honor, objection, that's beyond the scope of the questions that I asked on cross-examination, beyond the scope. So this way you can limit them in that aspect. Again, direct examination and cross-examination, it's fun. It's a conversation. My suggestion is, in particular, when you are cross-examining a witness, don't be a slave to your notes. Don't be reading your next question that you've written down while your witness is testifying. You'll be surprised how easy it is to cross-examine your witness if you merely converse with your witness. It's just like a good debate or a good argument. Cross-examination is fun and thrilling. It can be, at least in my experience, the most fun part of a trial. So when a witness says something, they might give you something that didn't even occur to you. Keep that in your mind. You might want to go back to that. You can explore areas of inquiry on cross-examination with little incremental questions. Frequently, you don't know, let's say you don't know if the officer smelled an odor of alcohol on your client when he was making his first approach at the accident scene while the defendant is still in the driver's seat, because he didn't write it in his reports and you really don't know. So you could run the risk of saying, well, you didn't smell the odor of alcohol, did you, officer, because you didn't write anything in your police report about it. And then the officer will clearly say, well, I apologize, counsel. That was just an oversight. I neglected to put it in my report, but I smelled an overpowering odor of alcohol. What you can do, if you want to explore that aspect without letting the witness know it, is pursue a series of incremental questions, innocuous questions. As you approached the vehicle, you were distracted, weren't you? Yes, I was. There were injured people around, weren't there? Yes, there were. You would agree with me that the fire truck was there and it had its oscillating lights on. Yes, it did. It was cold that night, wasn't it, officer? Oh, yes, it was. The wind was blowing, wasn't it? Now, you know that, obviously, because you've watched the dash camera videos. So you can get up to the point where if he says, I did smell, and then you may not even want to ask the question, but you can do the precatory aspect to get some information if you want to go there. And if it's not that important to you, leave it and don't explore it. Don't ever ask the question that you think the odds are that it'll be adverse to you. Closing argument is basically your third opportunity to present your theory of the case. Your first opportunity obviously was the opening statement. Your second opportunity was the conduct of the trial through cross-examination of the other side's witnesses and through direct examination and maybe even redirect of your witnesses. Now the third opportunity is the closing. Frequently, we don't get a lot of time to prepare our closing. We can think about it, and we should, but typically what I like to do during my closing is go through initially by way of topic in a chronological form. Again, I go back to chronological form because it's the easiest way for me to be organized as a trial attorney. Chronologically, in the beginning, you might want to point out where a police officer or a civilian occurrence witness called by the prosecution testified as to one aspect of the trial where you made some good inroads on cross-examination or got some admissions out of them. And then you might want to supplement that, well, you will want to supplement that with what your witness said, maybe the passenger in the vehicle or the civilian that was driving the other vehicle, that dovetails and coordinates. Then move on to the next topic and then the next topic. typically, what you want to do is end on a high note in your closing. Don't give them the big overture in the beginning. What you want to do is gradually, methodically, in a conversational tone, present why your client is innocent if it's a criminal case, if your client is not liable if it's a civil case, or why the defendant is guilty if you're prosecuting a criminal case. Now, always, always conduct yourself with respect for your opponent. Never, ever underestimate your opponent. If your opponent is an old, doddering man, don't think he doesn't know what he's doing. If he or she is a very young person, somewhat inarticulate, don't underestimate them. Remember that they can be as damaging as the most sophisticated counsel. Always treat them with respect. Try not to let the jury, or the judge for that matter, know that you've been unnerved or surprised or upset. In other words, don't let them see you sweat. Remember that your opponent and the judge, all they're trying to do is conduct themselves according to the rules of evidence, the rules of procedure, and the rules of law. Try not to let it get personal with you. End your closing with genuine and sincere appreciation to the jury, and sit down. Don't make any faces. Don't slam the table. Don't ever yell in court. You know, when I was a young guy, I used to do a lot of that stuff, and it took about 5 to 7 years to get it beat out of me. I've been much more successful since then. I hope this is somewhat helpful. I hope I didn't waste your time. But I will tell you that you can try a case with anybody. When you get your license, that Supreme Court says you can try a case. You can try a case as well as anyone. All you have to do is prepare for it. Read your reports, read your facts, know your law, immerse yourself in the position of the participants. Be there for that period of time, and you'll do a fine job. Thank you.